Pre-formation decision number 5 is the state of formation question, which state's law your entity gets formed under, and which state's annual filings you sign up for. The decision binds for as long as the entity exists. The cost of getting it wrong and changing course later runs into thousands of dollars in legal fees and lost time. And most coaches arrive at this decision having already absorbed advice from forums, podcasts, and registered agent marketing materials that don't apply to a solo coaching practice. The methodology in this unit cuts through the noise and gives you a 3-factor framework that produces the correct answer for your specific situation. You probably came into this video expecting me to point you toward Delaware. That advice is everywhere in founder content and is the dominant message coming out of any registered agent service trying to sell you their state package. I'm not going to give you that advice. What I'll do instead is walk through what forming somewhere other than your home state actually means operationally for a solo service business. The second registered agent, the dual annual reports, the foreign qualification filings, and let you see why that complexity rarely pays back for a coaching practice. The home state default exists for a mechanical reason most founder content glosses over. Operating your practice from a state, home office in the state, in-person sessions with clients in the state, advertising directed at residents of the state, means you are doing business in that state under that state's legal definition, regardless of where the entity was formed. States require foreign qualification for entities formed elsewhere, but operating within their borders. Foreign qualification means an annual fee in each operating state, a registered agent in each operating state, and a separate annual report in each operating state. Forming somewhere other than where you operate creates 2 sets of compliance to maintain, not one. Walk the actual bill for forming Delaware from a Colorado base because the math is rarely what coaches expect to see. Delaware side, formation filing fee, annual Delaware franchise tax, annual registered agent fee in Delaware, annual report filing. Colorado side, because you operate there, foreign qualification filing, Colorado registered agent fee, Colorado annual report plus state income tax on the income you earn anyway. The Delaware formation adds a layer of cost and compliance. It doesn't replace the home state layer. 2 sets of fees, 2 sets of filings, 2 sets of compliance deadlines to track, and you got nothing for the second set except the Delaware address on your formation certificate. 3 factors override the home state default, and naming them explicitly matters because each one applies to a specific situation that the average solo coach is not in. Tax treatment differential. Wyoming and Nevada have no state income tax, and if you can establish Nexus in one of those states, the savings can be meaningful. Court system quality. Delaware's Court of Chancery has 150 years of corporate case law and predictable rulings on contested governance, which matters when you have partners or investors. Planned multi-state operations. If you anticipate genuine operations in 3 or more states within 2 years, a neutral formation state may justify the complexity. Factor 1 is the tax differential, and the reality check on it is sharper than the marketing makes the savings sound. A P.O. box address in Wyoming does not establish residency. A registered agent address in Nevada does not establish residency. What establishes residency is an actual physical place of business, time spent there, and the documentation that backs up the claim under audit. The analysis is fact-specific and depends on your personal residency, your client base, where you deliver the work from, and how aggressive your home state is about chasing residents who try to relocate income across state lines. This is a CPA conversation with someone who has done multi-state Nexus work, not a decision to make from a YouTube clip. Factor 2 is court system quality, and the Court of Chancery story is genuine, but doesn't apply to the practice you're building. Delaware's Chancery Court has over 150 years of corporate case law and judges who decide governance disputes without a jury, making outcomes predictable in ways that matter when you have partners arguing over operating agreement provisions or investors pushing for board changes ahead of a venture round. For a single-member LLC with no partners, no investors, and no governance disputes available to litigate, the advantage of the Delaware court over your home state's commercial court is functionally zero. The forum doesn't help you if you'll never use it. The Delaware and Wyoming hype comes from two genuine facts that get extrapolated to situations they don't fit. Fact 1. Venture-backed companies prefer Delaware because their investors understand Delaware governance law and structure rounds around it. Fact 2. Wyoming and Nevada have no state income tax, which can save real money for residents of those states. Neither fact applies cleanly to a solo coaching LLC. You have no investors. You're not building toward a venture round. Your personal income tax is determined by where you live, not where your entity formed. For a solo coach with no investors, no partners, and no multi-state operations, the only party who benefits from your Delaware formation is the registered agent collecting the annual fee. 3 coaches, same question, 3 correct answers, and the answers track the factual situation rather than any general rule. Coach 1 in Oregon, home office in Portland, half her clients in the Bay Area working remotely. She forms in Oregon. Coach 2 in Texas, Texas resident with a heavy California client load delivered remotely. He nearly formed in Texas. His CPA caught the California Nexus issue, and he forms in California instead. Coach 3 in New York, currently a New York resident, planning a documented move to Florida in 18 months. She forms in New York now, then redomesticates to Florida after the move when the personal residency change is complete and documented. Coach 2 is worth slowing down on because the CPA save in that scenario is the move that protected the entire founding decision from a wrong turn. He was about to form in Texas because Texas has no state personal income tax. His CPA ran the math and surfaced that California asserts jurisdiction over LLCs doing business with California resident clients for compensation, which his coaching practice would be doing on day 1. California's $800 minimum LLC tax would apply regardless of where he formed, and forming in Texas would have added Texas franchise tax on top of the California exposure without removing the California one. The CPA conversation cost him a few $100s and saved him from a wrong formation that would have taken 18 months to unwind. If you're seriously considering a non-home state formation for tax reasons, that conversation belongs with your CPA before you file anything at all. The math depends on your personal residency, your client geography, your projected revenue, and your home state's Nexus posture, none of which a video can know about your specific situation. The CPA call typically costs less than a single annual registered agent fee in any of the candidate states, and it surfaces issues like Coach 2's California exposure that aren't visible from the surface of the comparison. Forming wrong and unwinding it in year 2 is one of the more expensive mistakes in the founding sequence. The pre-formation CPA call is the cheapest protection against it. Open the state of formation decision tree and walk it against your situation, rather than treating the home state default as automatic. List your home state plus any other candidate states you've been considering. Delaware, Wyoming, Nevada, anywhere a podcast told you to look. Walk the three-factor methodology against each one in turn. If no factor overrides the default, that's your answer, and you carry it forward into Unit 2.6 to confirm no residency edge case complicates the picture. If the tax differential factor genuinely applies to your situation, mark it as a CPA conversation that has to happen before formation, and don't file the paperwork until the conversation has happened.